Thanks for tuning in to the latest episode of I'll Allow It Nevada, your go-to podcast for swift access to Nevada judicial education. I'm Anne-Marie Mayu, your host, representing the Supreme Court of Nevada, Administrative Office of the Court's Judicial Education Unit. In this episode, we are digging deeper into the domestic violence discussion. Joining us as our respected guest is Melissa Mangiaracina. Melissa received her law degree from the University of Denver, where she graduated with honors and received the Melanie Hardaway Award for Academic Excellence. As an attorney, Melissa represented children in foster care, victims of domestic violence, seniors, and low-income individuals in Nevada. Melissa has worked in a number of quasi-judicial roles, including a Justice of the Peace pro tempore, a court-annexed arbitrator, and an administrative hearing officer. These experiences led Melissa to the field of mediation, where she now focuses her practice. Melissa currently mediates private disputes for Sierra Mediation, child protection cases for the Nevada Juvenile Dependency Mediation Program, and custody and guardianship cases for the 2nd Judicial District Court of Nevada. Melissa also mediates appellate cases as a settlement judge for the Nevada Supreme Court and is currently running for the Justice of the Peace for the 2nd Judicial District Incline Village Justice Court. Melissa, thank you for being here.
Thank you so much for having me, Anne-Marie. I'm happy to be here.
If I were to ask you, define domestic violence for me, how would you define that?
Domestic violence is defined by the National Coalition Against Domestic Violence as the willful intimidation, physical assault, battery, sexual assault, and or other abusive behavior as part of a systematic pattern of power and control perpetuated by one intimate partner against another. Really, what this means in a nutshell is that when we're looking at domestic violence, what we're looking for is this pattern of coercive and controlling behavior that may or may not involve physical or sexual violence. And a lot of times people think that physical violence equates to domestic violence, but that's not necessarily the case. Not all physical violence between intimate partners is domestic violence if there's not this pattern, this ongoing pattern of coercive and controlling behavior, because it's really that desire to control that intimate partner that drives domestic violence and what we're really most concerned about when we're working with intimate partners.
It sounds to me like it's kind of the intent behind it.
Absolutely.
Since you have worked as an attorney, Justice of the Peace pro tem, and mediator on civil cases in Nevada, what types of protections does Nevada law have for victims of domestic violence within the realm of civil law?
That's a great question. So I think that when people think about domestic violence, they tend to think about law enforcement and criminal law. But in the state of Nevada and really around the country, civil law also provides us with a lot of protections that we can use to help keep domestic violence survivors safe. In Nevada, some of the different areas that civil law provides protections for survivors of domestic violence are, of course, in the area of civil protection orders. But our family law code also provides protections for victims of domestic violence. Within the family law, there is a rebuttable presumption that there should not be sole or joint physical custody for a perpetrator of domestic violence. And we also have protections in our landlord-tenant laws. Our landlord-tenant laws specifically provide that a survivor or a victim of domestic violence can ask to have their lease terminated if they can show that they've been a victim of violence. And of course, outside of state law, there are federal civil protections as well, and there are immigration protections under the Violence Against Women Act. So we have a lot of different ways that we can protect survivors and help survivors that fall outside of the criminal arena.
So how do parties, attorneys, and judges avail themselves of these protections?
In the civil arena, there are different ways that parties can seek these protections that we have under civil law. The easiest, the most obvious, of course, is to produce evidence of a criminal history of domestic violence. And this can be shown through criminal findings. This can be shown through protection orders, which are actually, of course, civil, but those can be presented to the court as proof that there is a history of domestic violence. Another way to avail oneself of these protections would be to admit law enforcement assessments, like those that you talked about in your podcast with Dr. Payne. As Dr. Payne mentioned, though, survivors would have to waive confidentiality for those to be admissible, and you would have to have them. So you're only going to have those if law enforcement's been called to the scene. And we know that that's not always the case, that just because there's domestic violence, that doesn't mean that there's ever been any sort of law enforcement involvement. And in fact, statistically speaking, we know that 70% of domestic violence cases go unreported. So this means that there's a significant amount of cases that aren't going to have these criminal records or these civil protection orders in place or these law enforcement assessments.
That's a lot of cases that go unreported. That's a very scary number. So you were talking about criminal history and history of protection orders. When you're looking at a domestic violence case, is it Nevada specific criminal history and history of protection orders?
No, when we're talking about use of this as information as evidence in a civil case, we would not be limited to a criminal history within the state of Nevada or protection orders within Nevada. The civil cases are really just looking at some way for parties to establish that there's been a history of domestic violence so that the courts know that they can avail themselves of these protections. And we don't necessarily even need those types of evidence. It's easiest if we have them, but there are other ways, right, that parties can avail themselves of these protections, because we know that such a high percentage of the cases are not being seen by law enforcement, are not coming in front of the courts. So survivors can produce other types of evidence. They can produce, of course, photographs, history of text messages that are harassing or abusive, emails, voicemails, or other types of evidence that you would generally see. It's just that it's a little bit more of an uphill battle, right, for survivors to have to bring that evidence before the court. And they may or they may not have it. And so it makes it a little bit harder for survivors that do not have the benefit of having a criminal conviction that they can show the court or a protection order that's been issued in the past.
I could see that would be difficult to present that in court. So in those cases that you don't have that clear evidence of history and domestic violence, is it still possible for survivors to take advantage of these protections?
The short answer is yes, but the reality is that it is much more difficult to do so. Part of the challenge is that our society and our judicial system often really misunderstand what domestic violence is. And oftentimes I see that whether it's members of society, attorneys, or even judicial officers, a lot of people have this belief or this view that if there's no history of physical or sexual violence, or if there's no criminal history or a protection order in place, then there's no domestic violence. And we know that that's not necessarily the case.
Let's pause briefly for a commercial break. And during this time, I'd like to ask a favor from our audience. All Allow It Nevada isn't just an accredited continuing legal education podcast. It's also open to the public. We've crafted this podcast with the aim of connecting with communities and providing valuable insights into the Nevada judiciary. If you find these episodes valuable, kindly share the experience with your friends and family. Your support is greatly appreciated. Thank you. So you said 70% of cases were not being reported. What do we need to do to correct that? Because that's a big number.
I think the first thing that we need to do is start talking about it. one of the reasons that domestic violence is so prevalent is because it exists in silence. When you look at the statistics that are out there, we know that 1 in 3 women and 1 in 4 men have experienced some form of physical violence by an intimate partner at some point. The numbers vary depending on whether you're looking at physical violence, sexual violence, harassment, stalking. But what we do know and what is clear is that these numbers are much higher than most people realize. But because we don't talk about domestic violence, because it exists in silence, we are not doing our part to educate society and educate our legal system on what's happening behind closed doors so that we can start helping survivors and stopping the abuse. I think another part of the problem is that there are a lot of myths and misconceptions out there around domestic violence and what it is. So we've already talked about the biggest myth, which is that domestic violence is uncommon. We know that that's not true, and yet we're still not talking about it as if it is something that is surrounding us every day, everywhere we go. Another big misconception that we've already talked about is that domestic violence must involve physical or sexual violence. But we know that that's not necessarily the case. If you have never seen it, I would encourage you to take a look at the power and control wheel that was created by the domestic abuse intervention programs. And what they've done is they've created a really wonderful and helpful visual that gives us a picture of a wheel. And on the outside of the wheel is the physical and sexual violence. But the spokes that make up the wheel are all of the different ways that perpetrators can intimidate, harass, and emotionally abuse the survivors so that they continue with this pattern of coercive and controlling behavior without ever necessarily having to engage in physical abuse. Or oftentimes, they'll only have to engage in physical abuse once. And then they use these different tactics to continue with this coercive and controlling behavior. And some of the different types of tactics that you see, if you look at the power and control wheel, are coercion and threats, intimidation, isolation is really common. Batterers will isolate their partners so that they don't have any resources to turn to, so that they're alienated from their friends and their family. Batterers will also, as you see in the wheel, minimize, deny, and blame the survivor for the abuse rather than taking responsibility for their own actions. I see in my practice a lot of financial control where batterers will control all of the finances and perhaps give their partners an allowance, a very small allowance usually, but the partners will have little or no access to the bank accounts, little or no access to any sort of financial stability that would enable them to leave. Of course, we see a lot of emotional abuse, where batterers will use what's called gaslighting to make their partners feel like they're crazy, make their partners feel like they are the ones who have something wrong. And in fact, it's their fault that their battering partner is engaging in this behavior. I do a lot of child-related relief mediation, and what we see is that batterers will often use the children as a means of threatening or controlling their partners, threats to take the children away, threats to get custody of the children, or threats for immigrant survivors, threats to have their partner deported. And they tell them that they'll never see their children again. Of course, something that we see in the courts and is really important for those that are listening to this podcast to think about is the possibility of litigation abuse. We see this a lot where batterers, once their partner leaves them, will continue this abuse through litigation by filing pleadings, by filing motions, by keeping them in the courts. So they have to continue interacting with them through the courts, and they have to continue spending money on this litigation, which never goes away. So there are all these different ways that batterers can use these different types of controlling tactics without necessarily engaging in that physical and sexual abuse that we so often think is central to a domestic violence relationship.
You bring up a really good point, because common person isn't gonna really, their mind's not gonna go this route. I think I heard on the radio or something about an ad about, are you being financially abused? And I'm like, what is this? What is that? What are we talking about? But as I'm looking right now at the power and control wheel, it says it right there, using economic abuse, as you stated, and then litigation abuse I have recently heard of. But it all comes back to that, using that power and control, and that's the intent behind the abuse. So it's frightening, but it's also eye-opening, and I think this is part of the starting to talk about it, right?
Absolutely. And I think it's not just about educating the judiciary or the attorneys. Something that I see a lot is I see a lot of survivors who don't necessarily understand that this broader definition includes more than physical abuse. And I have worked with a lot of survivors who've said, well, my partner has never actually injured me. And I've sometimes wished that if they would just do that, then it would be clear what was going on here. But instead, they have all of these different things that they do to me to make me feel like it's my fault, to make me feel like I'm the one who's doing something wrong. And those are almost more powerful tactics that batterers will use. And so I think it comes down to educating everybody that these tactics are very problematic. They're incredibly harmful and damaging, and helping survivors understand that it's okay to seek help, to take advantage of these civil protections that we've talked about, even if there has not been a history of physical abuse, or if perhaps it's only happened once. That does not mean that they are not entitled to our protection and our assistance. And so I think getting for everybody to understand this broader definition is really important and really essential to helping break the cycle that is absolutely too prevalent in society.
When you have someone who's already experienced some of these other abuses, and now it's turning into litigation abuse, as a mediator, as a judge, as an attorney, how do you move forward with that case? How do you get justice for your client?
I think the answer to that is very specific in terms of which of those populations you're speaking to in particular. As an attorney, I think an attorney for a survivor, it's really important for attorneys to recognize what's happening in the case and to call it to the judge's attention and make sure that it's clear that everybody understands what's happening in that case. Oftentimes, judicial officers don't feel like they're in the position to make a decision on something that hasn't been raised by one of the parties. So it's incumbent on the attorneys to recognize what's happening in the case and bring it to the attention of the judicial officer so that that officer can act on it appropriately. I think when mediators run into this, they have a different standard that they apply to their practice. And I have run into this in my mediation practice at all levels of mediation. I have certainly seen this in custody cases where batterers brought the custody case, not because they necessarily wanted custody of the children, but because they saw this as a means of continuing to perpetuate this controlling and abusive behavior. But I've also seen it at the appellate level in the settlement judge program for the Nevada Supreme Court, where I have seen cases that are the result of many, many, many years of litigation, all the way up to an appeal to the Supreme Court, that are a result of what appeared to be continued use of litigation abuse, to continue to control, to attempt to bankrupt, and to really abuse the judicial system as a means of getting at their former partner. And as a mediator, we are ethically obligated not to mediate something if we cannot do so in a safe and impartial and fair manner. And so in those cases, I think if a mediator knows that this is happening, knows that the parties have not come to the mediation table in good faith and willing to work together in fair negotiation, then I think it's the mediator's ethical responsibility at that point to terminate the mediation. What gets a little bit trickier is what judges are supposed to do with this, because at the end of the day, the attorney can make the case to the judge, the mediator can terminate the mediation, and ultimately at some point the judge needs to make a decision. And so they're really in the hardest position, because the judges will have to take what they've heard and do their best to make a ruling that falls within the parameters of the law, keeps the survivor safe, and holds the perpetrator accountable. And it really depends in what area of law the judge is practicing in, but that's why our statutes give the judges some leeway, some ability to use that domestic violence finding to help protect survivors. And so that's where, when you have a family law judge that sees that this is happening, the family law judge has the ability to say, there's a rebuttable presumption against sole or joint custody with the perpetrator. That's where a judicial officer sitting on a landlord-tenant case can say, I am going to allow you to terminate your lease because you are a survivor. And that is where a judge that is handling a civil protection order case can step in and say, this is precisely what the law is here to do, to help protect you. Outside of that, it becomes tricky. And my advice to attorneys, mediators, and judicial officers is to look more closely at what's in front of them. We need to be looking at these cases differently. We need to stop asking, is there a protection order in place? Is there a history of a criminal conviction? And we need to start looking more closely at what are the behaviors that we're seeing in front of us? How are these behaviors impacting the other party? And if it appears that this is a case of domestic violence, what can we do through our role, whether it's attorney, mediator, or judge, to help make sure that we are doing our best to protect our community and protect survivors?
You really need to take each case at its face value, and I would imagine that would be difficult. Anyone involved with these cases see some of the same signs, some of the same infractions, some of the same, it looks the same, and yet you really need to look at it as each unique individual situation and then make the decision as to how to go forward from there.
Absolutely. And I think the key is see the signs, looking more closely at what's happening in each case and really asking the important questions so that we understand what's going on in a particular case, rather than relying on labels, relying on convictions, relying on these standard forms of proof that there's a history of domestic violence, but really looking at, like you said, what is happening in this case. And as an example of that, I do a lot of custody mediations. And I would say that over half of the cases that I do for the Second Judicial District Court in Washoe County involve some level of coercive and controlling behavior. And it is not uncommon for my conversations with the parties to reveal these types of coercive and controlling behavior through the course of asking questions and exploring more about the nature of their relationship. And oftentimes, the key words that I will hear are, my partner is so controlling, or my partner is narcissistic. That is probably not true, because we know that that is a mental health disorder that is identified in the DSM and that there are criteria that need to be met. But that is a term that people throw out there that I often hear as a bit of a red flag, that I need to start asking more questions and looking at what's actually happening in this situation. But when they start talking about the other person being controlling, or when you notice that they're really uncomfortable in the room or really quiet, right, that they don't seem like they are comfortable answering, that's when I think us judges, mediators, attorneys need to start asking more questions. It's easier to turn a blind eye. it's much harder to deal with cases that involve domestic violence. But it is our job, if we are going to be working with the community, we are going to be serving the community, we need to ask more questions. We need to be looking more closely at these signs of these other types of coercive and controlling behavior so that we can make sure that we are recognizing it, because we know it's there. We know it's 1 in 3 women and 1 in 4 men. So if we're not seeing it in that many of our cases, chances are it's there and we're just missing it.
Because you do need to look at not only the history, but the history of the actual case. So I would imagine that that first response to that domestic call and the information that the officers relay off of that to the courts is pretty important.
Absolutely. And like we said in the beginning, when you have that information, that's always going to be helpful, because that gives you a third party's description of what happened. It is much more difficult when you don't have a third party or a witness or somebody else coming into the courts to say what they've seen. And what we run into a lot, which is really difficult, is that batterers will often tell law enforcement that their partner was the perpetrator. And oftentimes law enforcement will show up and will not really know what that history is in that household. And I think that's one of the things that judges run into that's really a challenge, is figuring out which of the partners to that intimate partner relationship is actually the primary aggressor. And our family law actually allows for the courts to look at a number of different factors to figure out which person is the primary aggressor, including, our statutes even say, any other factors that the court deems relevant to the determination. And I think that the reason for this language is that the legislature recognizes that there's so much more to the equation than what was happening in that moment that law enforcement was called, or possibly even what was told to law enforcement when they arrived at the house.
You had mentioned that, sometimes when the law enforcement shows up, once they're called out to the location, that the actual aggressor will blame it on the victim. But do you ever find situations where both are equally being the aggressor?
That's an excellent question. And this is something that we still run into a lot, because when law enforcement shows up, it's really hard for them to find out or figure out which person is the primary aggressor. And those that are experts in the field of domestic violence would argue that it is not possible for there to be what we call mutual domestic violence. And we do see that term used sometimes in court cases, certainly by batterers in their defense. But those that work in this field would argue that that's not really possible, because true domestic violence, as it's defined and as we've already talked about, is a pattern of coercive and controlling behavior, generally over a period of time. And so what you need in that relationship is one person in a position of power, meaning that the other person is not in a position of power. So it would not be possible for there to be true mutual domestic violence. And I think it would be helpful to back up a little bit and talk about the reality, and I think I mentioned this earlier, that not every form of physical violence between intimate partners is going to rise to this definition of domestic violence, which is, of course, this pattern of coercive and controlling behavior. When I train on domestic violence, I talk about the different types of violence that the courts might see, that attorneys might see, and that, of course, mediators might see. And there are 4 different types of violence that we see when we practice in the court system, but they're not all domestic violence. So just because there's violence between intimate partners does not mean that it's domestic violence. So let's walk through what those 4 types of violence are. One type of violence that might be seen in the court system is what we call situational violence. When this happens, there's no pattern of coercive and controlling behavior over a period of time. Imagine the scenario where one person cheats on their spouse. Their spouse finds out and they slap them across the face. That is physical violence. It is not okay, but it's not necessarily domestic violence. It may be an isolated event that was the direct result of learning about the cheating behavior. That may never happen again in that relationship. That would not qualify as a pattern of coercive and controlling behavior. That's what we call situational violence. Another type of violence that we might see in the court system is what has been called resistive or reactive violence. Reactive violence or reactive abuse occurs when the victim of domestic violence becomes the aggressor against the abuser. And they might engage in physical behavior, pushing, punching, kicking, pulling hair, raging, or even verbal attacks. This is different from domestic violence because, again, it's not a pattern of coercive and controlling behavior, but instead it's a reaction to that ongoing abuse that they have been experiencing. And it is the result or the reaction, right, to being in this situation where they have been coerced and controlled over a period of time. And I want to throw out there that this is the term reactive violence or reactive abuse that's been used for years. But I did recently read an article suggesting that we really need to take another look at what we call that, because this is more like self-defense. This is the reaction to an ongoing pattern of abusive and controlling behavior. And so really, I think it's time, and I agree with the person who wrote the article, it's probably time that we reframe this and we start calling it someone else. But I just use the term here because that's what folks will be familiar with. But really what this is a reaction or a response, more like what we see in cases of self-defense, where a survivor is reacting or responding to that ongoing abuse. And then a third type of violence that we see in the courts is the result of pathological or antisocial behavior. And that might be the result of mental illness, substance abuse, brain injuries, and it's not generally part of a larger pattern of coercive and controlling behavior. When you see that type of violence, you might see violence between intimate partners, but you probably are going to see that person using violence outside of the home as well. So maybe at their workplace, maybe in the school setting, maybe in their community. That's not usually characteristic of a domestic batterer who can come off as very charming and manipulative within their community. Oftentimes, communities will be surprised to hear that a batterer is engaging in domestic violence because they aren't the type of person that's doing that out in the larger community. And they tend to be very, very charming. And so I think it's important for courts, attorneys, judges, mediators to really start looking at these different types of violences for what they are, and not saying just because they're intimate partners and there is physical violence, this is domestic violence. And that's where that definition comes into play. We're educating everybody on what is domestic violence so that we can understand that it's really this nuanced pattern of control that's really problematic, so that we can start getting to the heart of that in our decisions and in what we do when we're working with our clients.
Well, that, and like with anything, that makes a huge difference to really understand all four different types of violence and, recognize them. Where can judges, attorneys, and others educate themselves on the dynamics of domestic violence so they can start looking at these cases a little differently?
There are a lot of really great resources out there. Those that are working within the realm of family law, I would encourage to reach out to the National Resource Center on Domestic Violence, Child Protection and Custody. They are able to provide trainings. They offer technical assistance. They do a lot of good work in this area for family court judges, but also those working within the systems. The Battered Women's Justice Project is also a wonderful source of information. They have a lot of information online. They now house the National Resource Center on Domestic Violence, Child Protection, and Custody. And so they have a lot of great resources for family law folks as well. And I think the key is just to continue educating. And I also am a co-founder of the Mediator Training Center with Margaret Crowley, who lives also in Reno, Nevada. And we have a number of on-demand courses online. I have an Introduction to Domestic Violence course that's called Domestic Violence for Family Court Professionals. It is not just for family court professionals, though. It is for anybody that might be working with families, with intimate partners that might be experiencing domestic violence. I would love to have everybody take that course, and I am happy to offer it for free for anybody who's listening to this podcast today. You can go to www.mediatortrainingcenter.com and go ahead and select that course. When you are taken to the checkout page, you can enter podcast into the coupon code, and that will give you that course for free. I am happy to share this information. This course goes into more detail than we were able to go into today in terms of what is domestic violence, how can you recognize it, how can you distinguish it from other types of violence, and it's hopefully a good place for folks that are working within the legal system to start thinking differently about these cases so that we can start providing better services for our communities.
Well, we appreciate you offering that course for free for anyone who is listening to the podcast. Thank you so much for doing that. We'll make sure we post that information where we put the description of this podcast up so people can access it much easier. This has been a ton of information, just an education in itself these past 30 minutes. So I appreciate you sharing all you know. Was there anything else that you feel like we didn't touch on that you'd like to share? I'm sure there's hundreds of hours of information, but was there any other ideas that you would like to share today?
You know, we give 3-day trainings on domestic violence. So like you said, there's so much to share, but I think the key is just that if folks have signed on for this podcast, then that's the beginning of a really important conversation. So I would encourage any listeners to not end here. This is just the tip of the iceberg. Please keep educating yourselves on these really important issues. This is such a vast field. These cases are present in every day and everything we do. And so I just appreciate the opportunity to start sharing what I know. And I'm always open to talking about this. If anybody wants to reach out, I'm always happy to help in any way that I can. So thank you so much for having me.
Thank you, Melissa, for being here.
A big thank you to our guest, Melissa Mangiaracina, and to everyone tuning into this podcast. I would like to encourage our audience to continue the domestic violence discussion in an effort to help educate more about this topic. Just a quick reminder, if you're seeking continuing legal education credit, please complete a certificate of attendance and email it to jepodcast@nvcourts.nv.gov. Additionally, if you have any topic suggestions, ideas, or comments to share, feel free to email us at jepodcast@nvcourts.nv.gov. We're always eager to hear from our listeners. Stay tuned for more episodes of I'll Allow It, Nevada, released every first and third Friday of the month. This is Anne Marie Mayu signing off. Take care, Nevada.